Hello, everybody. Welcome to the 2021 Victor S. Johnson Lecture. I'm Ingrid Wirth. I'm the Associate Dean for Research at Vanderbilt Law School, and it is my pleasure and privilege to introduce the lecture and today's speaker. First, however, let me thank Bernadette Paschal-Graffried and Kira Cruz Street and many other people for all of their work organizing this event. The Victor S. Johnson Lecture is made possible by the generosity of the Johnson family. Victor S. Johnson III is one of our distinguished alums. He served as the District Attorney General of Nashville and Davidson County for more than 26 years. We're grateful for his many contributions to our city and to our law school, and I'm very happy to say he is in our Zoom audience today. Our speaker today, Daniel B. Rodriguez, is the Harold Washington Professor at Northwestern Pritzker School of Law. He will speak on a general theory of the police power. He will discuss the powers that state government officials have to protect public health, safety, and welfare. That topic is a perfect fit for the COVID era, which I fervently hope is coming to an end. It is also a perfect fit for the Johnson Lecture, which focuses on public policy and serves as one of the intellectual highlights of each academic year at the law school. Our speaker, Professor Rodriguez, is one of the nation's leading public law thinkers and writers. He was educated at California State University, Long Beach, and Harvard Law School. He has served on the faculty at Berkeley, San Diego, Texas, in addition to Northwestern, where he was also the dean of the law school from 2012 to 2018. His scholarship is of great range, great depth, and great impact. You can read about his many honors and accomplishments online. You can join thousands of others and follow him on Twitter. And best of all, you get to listen to him speak right now as part of this lecture series. Thank you so much for being here. The floor is now yours.
Thank you so much, Ingrid. Let me, as we always do in the Zoom universe, check my sound and make sure you can all hear me. I know I'm off mute. Great. I want to begin by joining in the thanks to the Johnson family. It's an honor to be able to speak and to give a lecture in the name of such a distinguished alumnus of Vanderbilt Law School. And it's again, just a great honor. I want to thank Ingrid. And I also want to thank especially my friend Jim Rossi, who thought of inviting me out to give the lecture when we expected to join together there in Nashville and in Vanderbilt. And I know Jim and I had great plans, and I had great plans to be with you. It's always a regret and a sadness, of course, to not be able to join together in a workshop, in a lecture setting. But it's a special sadness here with me and in Vanderbilt, given what I've had, just an enormously wonderful set of friendships with colleagues there at your law school, and have enjoyed many adventures at Vanderbilt and at Nashville. It was a sort of a cruel 1-2 punch that as I was working on this lecture on Sunday evening and had the Grammys on in the background, one of the virtual presenters was the owner of the Station Inn, just to rub it in that I wouldn't be in Nashville and be able to join you. But my wife has promised to bring me some Nashville hot chicken later, so maybe I can solve my wounds for at least a little bit. But in any event, I won't go on more except to say I look forward to be able to join you in person just as soon as I possibly can. Thanks again for giving me the opportunity. So my topic is the state of police power. And I suppose I should say, as with the introduction of celebrities, this is a topic that needs no introduction. But that wouldn't be quite right. It is a doctrine that is at the same time very familiar, but also very elusive. Justice William O. Douglas said about it, "Any attempt to define its reach or trace its outer limits is fruitless." It is something that is one of the very first things that perhaps we focus on when we began our study of constitutional law as law students, but also something that we largely take for granted. It is a doctrine that is hoary and seemingly moribund, with the last major Supreme Court decision from 1905, so more than a century ago. But this doctrine has come into vogue in just the last year as as Ingrid mentioned, with a number of controversies involving the scope of the state governor's authority, and to some extent legislatures and agencies as well, to impose myriad restrictions in this COVID-19 pandemic. Such a centrally important doctrine to our American constitutionalism, but such a puzzle. I described in a paper for a talk I gave at NYU a few years ago, the police power as, quote, inscrutable but irrepressible. And I stand by that depiction, even though my thinking about it has evolved since then. So as a puzzle, and one that is pertinent to contemporary state constitutional law at the very least, it deserves our close attention. The title of my talk, A General Theory of the State Police Power, is a hopelessly ambitious one, and that deserves some explanation, lest you think of me as coming to you with unbridled hubris. The state police power needs a theory precisely because neither the text nor the history nor the doctrine created in many decisions from many different state courts and some federal courts gives us the necessary guidance to resolve disputes about its function and its limits. It needs a theory for essentially the same reasons as does, for example, freedom of expression, the separation of powers. We cannot just stare at the words or recover the history and hope to figure out what it means and how to apply it. We need something more than that. And it is important to think ambitiously about a general theory because otherwise the policy contexts in which the police power arises will unnecessarily confine the contours and perhaps circumscribe this power when we might need it the most. Maybe that's a spoiler alert. So to take the example most prominent on our collective minds, even if we develop a good approach to addressing public health pandemics through, among other things, state and local regulation, we won't necessarily make much progress in addressing, say, the use of the police power to safeguard public morals or to protect the environment, or frankly, to limit the scope of policing. Working toward a general theory, I would argue here, and maybe also suggest at the end of my talk, is a worthy aspiration. At least it is my aspiration, and hopefully you will see it as such by the end. So this is enough foreshadowing. Let me turn to the topic in earnest. I'll begin by discussing the origins of the police power in American constitutionalism, defining origins broadly to encompass not simply the matter of the framers' intentions, supposing that we can ever do such a thing as to discover them, but more or less the first century of our constitutional republic. We should care about these origins, I argue, for reasons other than merely the recovery of the legal history of a concept. Next, I will shine a spotlight on a case that has become of special contemporary interest as a result of the COVID pandemic, and that is Jacobson versus Massachusetts. That's the 1905 case that I alluded to earlier. And with both the origin story and also perspectives on the conceptual tensions in ascribing purpose and meaning to the police power, I will turn to the matter of a general theory, sketching some ideas with the benefit of some contemporary real-world examples. Even folks who disagree mightily about much in our story of American constitutional development will hopefully agree that the police power became quickly embedded. I shouldn't say quickly embedded, it became embedded from the very beginning into our law at the time of the Constitution's creation. So let's begin at the beginning with the fundamental principle that the United States Constitution is a document of grant. That is, it delegates to the national government limited powers. This idea is entrenched formally, of course, in the 10th Amendment. The framers juxtaposed these limited powers, the federal government, with the comparatively wide powers given to the state governments. As Madison wrote in Federalist 45, the powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are, he said, numerous and indefinite. The imprimatur the framers put on the state police power revealed an extraordinary grant of power, and with it, the states possessed, as was said recently by one scholar, a staggering freedom of action. The police power is typically described in the scholarly literature in connection with the debate over whether and to what extent the national government has something akin to a police power. While at first glance, this argument about federalism seems orthogonal to the question of what meaning we should give to the state's police power, which is after all the topic of my talk today, these are not entirely separate inquiries. The idea of the state police power is embedded, to be sure, in larger conversations about American constitutionalism generally, including both the federal constitution, the United States Constitution, and the 50 state constitutions. The political scientist Gary Gessel, now at Cambridge, University of Cambridge, and if my recollection is right, was previously at Vanderbilt, argues that there were really twin constitutional origin stories. The framers viewed the US Constitution as a document focusing on liberty, he argues, and the state constitutions would have a more Republican focus. He views the police power as Exhibit A in that description. This power underwrote, writes Gessel, an American theory of governance that was collectivist and majoritarian rather than liberal, end quote. That this theory of governance was manifest only in state governments remains elusive in Gessel's account, as I'll just notice and pin, but won't go into in much more detail. But let's do this. Even if one views the state constitutions as having this Republican valence, as Gessel argues, we need to know where this vision comes from. The idea of the salus populi, forgive my Latin, the whole maxim read as, and it only gets worse, salus populi suprema lex, reflects the common law's insistence that the people's welfare is the highest law. And to the police power, as described, for example, by legal scholar Marcus Duber, writing about the connection between police power and the criminal law, is, as he says, quote, the inherently unlimited extra-constitutional discretionary prerogative of the sovereign to act quickly and expeditiously so as to eliminate threats to the health, safety, and security of the people. This idea, and drawing into it the function of governance as protecting our so-called overruling necessity and the public welfare, health and well-being of our citizenry, would go on to become, as William Novak writes, a major principle of American common law and one of the key bases of US regulatory power, a foundation, he goes on to write, for modern American state power in general. Clearly, the framers of the early American state constitutions draw not only inspiration, but also advice from the great pre-revolutionary thinkers. Just focusing on the lawyers, Blackstone and Vattel, they identified the power with a sort of paterfamilias role. The idea was that the power acknowledged the enduring role of the sovereign in ensuring that, as Blackstone wrote, domestic order would be preserved by due regulation, order that would protect individuals who were, as he put it, like members of a well-governed family and are bound to conform their general behavior to the rules of propriety, good neighborhood, and good manners. This reveals, I would suggest, an almost tranquil vision of the police power. We want peace and prosperity. We want good neighborhoods. We want protections from bad elements and bad people. And our wise fathers, acting with the authority of the state, will give this to us just so long as they have the constitutional power to do so. But of course, this tranquility comes at a price. And that price was understood by Blackstone and others who were drawing from these ideas to establish mechanisms of authority in our early state constitutions. The framers could have expressed these notions with language of regulation, but instead they spoke about this through the language of police and control. This was not merely, or even especially, a regulatory power, a social welfare power, but as the framers wrote it into the state constitutions, a police power. And here too, it is important to remember that this term had its history as well. While the etymology of the term police, coming from French via Latin and then to the British Isles, is beyond the scope of my inquiry, it bears noting that as it came to Blackstone and the earliest thinkers about the police power, it was understood as meaning, quote, regulation, discipline, and control of a community, civil administration, and public order, law and order. This emphasis on control and order could understandably be seen as threatening and overbearing. And it indeed was so understood by, for example, Foucault, who described the police power as, quote, the direct governmentality of the sovereign as sovereign, the permanent coup d'etat. The somewhat nuanced but important, I would argue, distinction between the police power as something public authorities are doing for people and something governments are doing to people was interrogated in some of the important 19th century cases involving the meaning of the police power in both the state and also the federal courts. So for example, in 1847, in the license cases, Chief Justice Roger Taney associated the police power as, quote, nothing more or less than the powers of government inherent in every sovereignty, that is to say, the power to govern men and things. This sourcing of the police power and the idea of management and control was expressed even more extravagantly by a Vermont justice just 1 year later. He writes, all governments, upon the most obvious principles of necessity, exercise more or less of preventive force in regard to all subjects coming under their cognizance and control. He went on to say that these wide variety of regulations, quote, all come under the right of preventing more serious injuries by stifling the fountains of evil. The idea of the police power as the means by which the paterfamilias maintains good social order to control, as Tani wrote, men and things, evolved, however, and there became indeed a more benign view. The lodestar of this view was Chief Justice Lemuel Shaw's opinion of the Massachusetts Supreme Judicial Court in Commonwealth versus Alger, tellingly viewed as the most important early state case on the police power. Alger involved what we might see now as a rather conventional and even prosaic exercise of regulatory power to limit a private property owner's discretion to build a wharf that would impede navigation. In upholding the Commonwealth's power, Chief Justice Shaw declared that the police power was, quote, power vested in the state legislature to make, ordain, and establish all manner of wholesome and reasonable laws, statutes, and ordinances as they shall judge to be for the good and welfare of the Commonwealth. The tension, I would argue, between this social control view manifested in Blackstone, manifested in Tawny's opinion and the Vermont opinion that I mentioned, and the view of the power as about promoting the general welfare through reasonable regulation was not resolved decisively in the first century of our constitutional republic, nor even really in our second century. The extensive case law in the police power, principally in the state courts, but with occasional forays into the issue by SCOTUS, reveals different approaches, or at least different emphases. Before returning to what some of the judges had to say, let me pause to note what was actually going on in the states and local governments as government officials deployed these awesome powers. We know from the exercise of broad regulatory and fiscal authority in the nation's first century that state governments were acting quite boldly to construct great works to expand state capacity and the American empire. The building of the Erie Canal was an important development, both practically and symbolically, as were other public works which necessitated the regulation, taxation, and in some cases, the confiscation of private property. On this last point, we should see the evolution of the police power in parallel with the evolution of other key governmental powers, including eminent domain and the taxing power. These were all tools in the legal toolkit, and states availed themselves of these powers in undertaking important infrastructure projects, among other projects. They also worked hard at protecting public morals, and again, recalling Blackstone, the good neighborhoods of their communities, and there are many illustrations of state and local statutes that assign such powers to government officials, as there were state cases upholding the exercise of such power under the state police power. Economic progress through building and managing resources, preventing threats to safety and public health, and securing good order for the well-being of the community, all of these were noble purposes and are noble purposes. And what could be wrong with reinforcing the government's authority to all these good things? And yet this is not the whole story, not nearly. We cannot understand the 18th century history of the police power without seeing how it was used as an important and deliberate mechanism by which the southern states in colonial America and through the antebellum period protected slavery, a point I should say others have made certainly before I have. There is not enough time here to go into detail on the use of the police power to promote and protect slavery in the southern states, or to look post-Reconstruction at the use of this power to promote Jim Crow. This is a big and important topic, and any comprehensive historical treatment of the police power needs to confront this in extensive detail. I will simply note that this power was indeed deployed tactically by southern and northern states to legitimate broad state power to keep their states, as they saw it through noxious eyes, protected against what they perceived as internal threats to their good citizens' welfare through integration. In no less a Jim Crow icon than Plessy versus Ferguson, the Supreme Court, for example, the Supreme Court invoked the police power as the power to regulate health, safety, and morals in order to justify the Louisiana law. More generally, the continuing reliance on the state police power to support the steady expansion of the role of state governments in constructing public policy continued after Reconstruction. In Munn versus Illinois, decided in 1877, the Supreme Court declared that police power would support regulation of grain warehouses. Under these powers, said the court, the government regulates the conduct of its citizens one towards another and the manner in which each shall use his own property when such regulation becomes necessary for the public good. 10 years later, in Mugler versus Kansas, the Supreme Court upheld a state regulation on the manufacture of liquor, insisting that, quote, the state can take possession of the persons and property of its citizens, absolutely, and so to regulate and reform them as to produce the ideal father, husband, and taxpayer of the commune. These watershed cases, and cases less familiar because they were decided by state courts interpreting state constitutions and thus never made our con law casebooks, ushered in a period in which state governments exercised broad authority to advance the public welfare. Much of the leading scholarship on the history of regulation and constitutionalism in this critical period, from Reconstruction into the progressive and populist eras, and ultimately to the New Deal, focuses on the emergence of substantial federal regulatory authority, what Stephen Skowronek calls the expansion of national capacities. The principal narrative, as William Novak explains in his very important book, The People's Welfare, is how the police power turned into, he says, quote, a powerful font of state and ultimately federal regulatory authority. And it did so through what it was essentially expropriation. Indeed, what he calls, quote, one of the most significant expropriations of political power in American history. This story, one of states holding the bag essentially until it became imperative and tolerable for the national government to step in and use through the same or reconstituted strategies these powers for more national purposes, is too pat, I would argue. Yes, of course, the history of 20th century constitutionalism is one of steady expansion of national power and likewise encroachment on state prerogatives through federal action. But what is left out of this story is the purposive use of the states during this same period of regulatory authority to enforce policies that were ambitious and tied more squarely to state and local objectives. Moreover, and this is a key but neglected point, much of this expanding state authority was not accompanied by broad national authority. Much of the prerogative to prevent threats to the health and safety of citizens and to promote the common welfare indeed remained at the state level. So think, for example, of zoning and various moral laws. These emerged from state primarily and not national political choices. To be sure, some, as with prohibition, evolved into national edicts. Others, however, including zoning and safe housing laws, to take two examples, not to mention ordinary police regulations, stayed squarely at the state and local level. This didn't happen by historical accident. In the 19th and early 20th centuries, new state constitutions were adopted and existing state constitutions were often significantly amended. These constitutions were central weapons in the arsenal of state and local authority to implement public policy objectives through regulation and other means. And while the police power was not created through these efforts in the 19th and the 20th centuries, for it had been well established by then, this power became ever more important as a fulcrum for state and local governments to implement policy goals and to prevent harm. The rise of the states, to borrow from a title of a book by urban historian John Tieford, was a result of the expanding needs and expectations of the community at the state and local level. So, for example, the emergence of Euclidean zoning and various health and safety regulations was not a product, I would argue, of technocratic scientists looking to employ their newfound expertise to address emerging social problems, as much as it was a response to an era in which real solutions and, as someone once wrote, the productive energies of society were deemed by its citizenry as necessary. State and local governments undertook meaningful regulation both to prevent harms and to secure common goods under the rubric of the police power. Returning to William Novak, perhaps our leading legal historian of the police power in this period, he viewed the steady expansion of federal power in the post-progressive pre-New Deal era as evidence that the police power, quote, began to go national. But that is not quite right, I would argue. States maintained enormous latitude to regulate, and they used that latitude to impose many regulations on private property, including myriad housing restrictions and extensive strategies of social control. Indeed, in the midst of the New Deal, a New Jersey court said in a case involving a state regulation on the importation of unsafe milk, quote, the police power extends to all the great public needs. All personal as well as property rights are held subject to this reserved element of sovereignty. Changing conditions necessarily impose a greater demand upon this reserve power for such reasonable supervision and regulation as may be essential for the common good and welfare. And it concluded with a flourish. It may be exerted whenever necessary for the preservation of the public health, morals, comfort, order, and safety. If the police power was to become truly nationalized by the time of the New Deal, as Novak says, perhaps the state legislatures simply didn't get the memo. However, the police power, all said and all told, was not without scrutiny and not without limit. Just as these state and local governments were emerging as vital regulatory forces, there also came pressures from the other direction, that is, to limit governmental ambitions. Thomas Cooley, in writing about constitutional limitations during Reconstruction, anticipated some of these competing pressures. So too did the important, if now somewhat neglected, treatise writers of the period, including John Dillon, whose influence was felt through the rule that bears his name. That rule counseling a narrow and textualist grounded view of local power under state constitutions. Central to these efforts to restrain governmental power was an ambient concern that state legislative power had, in its capaciousness, become decoupled from popular will. It had become, in short, anti-democratic. This concern, percolating a full century after the framing, mirrored in key respects the framers' original concerns with the threat posed by a mercurial executive branch. And the first 13 state constitutions indeed manifested this concern through structural constraints. In the case of Pennsylvania, for example, abandoning entirely, at least at the first go, the office of the governor. The principal mechanism to ensure energetic state government that would be facilitative of both democracy and liberty was the establishment of a plenary legislative power, a power that gave foundation and shape to the police power. Let us recall that the police power, as originally understood, was indeed principally a legislative power. The first principle of state constitutionalism, that state constitutions are documents of limit, understands the font of state constitutional authority to be found in the legislature. As the Illinois Supreme Court put it in 1879, under traditional constitutional theory, the basic sovereign power of the state resides in the legislature. Historian Gordon Wood ascribes this view not in some free-floating idea of constitutionalism qua constitutionalism, but in revolutionary era conceptions of state authority. The revolutionary central aim, Wood writes, was to prevent power, which they identified with the governors, from encroaching on liberty. Thus, in all the state constitutions, the much feared governors were radically weakened and the popular assemblies or houses of representatives greatly strengthened, he writes. And as the state legislatures had plenary power, the remaining question, was how would this power be limited? To say it would be limited by national action is to engage in post hoc ergo propter hoc reasoning. After all, this notion of state plenary power predated both the rise of national power to preempt state authority and also incorporation doctrine. That the breadth of state legislative power was tied to the democratic quality of state governments and the proximity to the people was an important part of our system of American constitutionalism and original constitutional tradition. As Gary Gessel has noted, quote, more than the central government, state governments were thought of as embodiments of the people. And from this, it followed that the people would not ordinarily require protection against themselves. The theory of power on which authority of the states rested called for the people to be made sovereign. It invested state legislatures, the bodies representing the people, with broad authority to act for the good and welfare of the Commonwealth, end quote. Later generations would wrestle with this idea and also with the performance of state constitutions. In the post-Civil War period, there emerged a growing skepticism about the conduct of state legislatures, and reformers developed myriad mechanisms to control legislatures and to assign to other governmental institutions, including governors and municipalities, a much greater role in making policy and in checking legislative excesses. I have here in quotation marks that municipal home rule and initiative lawmaking was created at the same time as state constitutions were being amended to cabin legislatures is not a coincidence, but that is a story for another day. Okay. While the police power was designed as an expansive power to govern and was being used by state legislatures as such, it did not evolve into a one-way ratchet. The experience of constitutional reform and judicial intervention from the beginning of Reconstruction through the New Deal reflected a serious and growing concern with broad state legislative power. The fears of a runaway state legislature were met mainly through two strategies during this era. The first was close attention to and ultimately reform of state constitutions in order to create new checks and balances. The progressive era, as is well known, brought many changes to American state constitutionalism. Fear of legislative rent-seeking and a decoupling of popular sovereignty with legislative representation. Fearing that, reformers imbued state constitutions with various limits and rules on legislative decision-making and legislative procedure. These revisions included new restrictions on state lawmaking, for example, through balanced budget requirements, prohibitions on special legislation, requirements that laws have a public purpose, and other procedural rules. These limitations were intended to be, and always would become, mutually reinforcing. They would channel state efforts to regulate individual and institutional conduct in order to ensure that the objectives of state governance would be protected. These good government efforts helped forge, albeit indirectly, new mechanisms for the police powers exercise. The other principal response to the threat of expansive state police power came from laissez-faire constitutionalism embodied in the Lochner era, beginning just after the turn of the 20th century and continuing for several years afterward. This lecture is not the place for an extended treatment of Lochner era jurisprudence and the struggle over the scope of the police power in the federal courts. What I can and will say just very briefly is that the emergence of this so-called laissez-faire constitutionalism reflected a concern with not only strategies state governments were using to implement welfarist goals through restrictions on private property and individual liberty, but also with the purposes that these strategies invoked as a rationale for regulation more generally. For example, in an important article on the history and scope of the constitutional police power, Randy Barnett has pointed us usefully, if controversially, to the natural law origins of the economic liberties and the corresponding limits imposed in Lochner and its aftermath, and hinted at more obliquely in federal and state cases involving substantive due process and privileges and immunities before Lochner. Barnett may be right in his densely argued account of the original meaning of police power and legal limits, but suffice it to say here that the courts, including the United States Supreme Court, had not resolved the tension by the time of Lochner or even afterward over whether the police power was principally intended to be preventive of social harms, as in and individual harms. Actually, let me start that over. Was principally intended to be preventive of individual harms, as in the principle sic utere tuo et alienum. I'll quit while I'm ahead. Let's just call it the sic utere principle, which is do not harm another with the use of what's yours. Or was it instead, as I discussed earlier, the fulcrum of a broader role of government as promoting the general welfare, thus permitting and perhaps even requiring steps to redistribute the blessings of liberty and the good of society from the advantaged to the disadvantaged? Interestingly, a case decided just 1 year before Lochner represented the single most important foray by the court into the question of how best to balance a broad state police power with the imperatives of civil liberty. This was, of course, Jacobson versus Massachusetts, a 1905 case arising out of the loathsome smallpox pandemic of that era. The connection between this case and our present pandemic is obvious, and so that, among other reasons, warrants a closer look at Jacobson. Jacobson involved a mandate from the state public health authorities in Massachusetts that individuals over the age of 18 be vaccinated against smallpox. This edict came to the legislature through local public health officials in Cambridge, Massachusetts, who were moved by the science to undertake rapid efforts to halt the spread of the pandemic. Sounds familiar? The principal claim of one Mr. Jacobson was that this requirement violated his due process and equal protection rights. It could not be justified, he argued, as an adequate basis for displacing his civil liberties. While public health emergencies were not new by the early 20th century, the court had few precedents to draw upon to evaluate the constitutionality of these public health restrictions. Massachusetts ultimately invoked the police power, and the court agreed that the public health order was warranted by this power and that Jacobson's civil liberties were not a basis for displacing such authority. Justice Harlan, for the court, noted that they would refrain from any attempt to define the limits of the police power. Yet, as he noted, the court has distinctly recognized in the past the authority of a state to enact quarantine laws and health laws of every description, indeed all laws that relate to matters completely within its territory, and which do not by their necessary operation affect the people of other states. The conclusion that state health authorities were within their prerogative to establish this mandatory vaccine requirement, and further, the court's role in second-guessing this judgment was appropriately limited, was truly the easy part of the court's decision. Although not entirely free from controversy, then or now, the recognition that science-based decision-making counsels deference and that the protection of public health is well within the wheelhouse of the police power, however broad or narrow its remit with respect to general welfare regulations of various sorts, was compelling. And indeed, Jacobson has become an iconic case around which law and public health leaders rally to this day, both before and during our current pandemic. More difficult, however, was how to draw sensible limits on state public health measures, where such measures impacted significantly individual liberty. In recent commentary on Jacobson and its legacy, a number of public health law scholars have argued, correctly in my view, that Jacobson did not propose any sort of minimalist scrutiny of constitutional protections in the case of public health emergencies, nor should Jacobson be read, as did the Fifth Circuit in a recent COVID case involving abortion restrictions, as proclaiming, and I quote, all constitutional rights may be reasonably restricted to combat a public health emergency. Perhaps the most interesting and important part of Jacobson's legacy is that while the public health case for deference to state officials acting under the police power has remained intact, our constitutional rights jurisprudence has gone through enormous evolution in the 120 years since that case. At this point, I was going to talk a bit more about incorporation and the rise of tiers of scrutiny, but in the interest of the time, let me pass that by and turn actually to one of the most important, maybe the most important applications of the Jacobson principle in recent jurisprudence. And by recent, I mean a few months ago. And that is the religious liberty decisions, and in particular, Roman Archdiocese versus Cuomo, in which the Supreme Court struck down a public health regulation on the grounds that it violated the First Amendment guarantee of religious liberty. By contrast to the majority opinions in the two earlier cases, a few months earlier, where Chief Justice Roberts wrote in his concurring opinion that, quote, our Constitution principally entrusts the safety and the health of the people to the politically accountable officials of the states to guard and protect, the court changed its mind. Of course, by the time of the Brooklyn case, Justice Ginsburg had died and been replaced by Justice Amy Coney Barrett. Not only did the court instantly change its outcome, but the per curiam opinion in Roman Archdiocese declined to cite Jacobson at all. Even if the Constitution has taken a holiday during this pandemic, wrote Justice Gorsuch in a dissent in an earlier case, it cannot become a sabbatical. Once again, I'm going to, in the interest of time, dispense with some comments about whether there's anything left of constitutional requirements in the form of proportionality or reasonableness restrictions on government regulation. I'm happy to talk about that more in the Q&A, but suffice it to say that Jacobson has been invoked, as I rechecked it this morning, nearly 300 times during the period of COVID for a variety of principles, both in favor of state regulatory power or against it. I should say that Jacobson has been the go-to source case for examination of COVID restrictions. It has a Rashomon-like effect, meaning different things to different people, or perhaps the better analogy is a Rorschach test, with the courts relying heavily on Jacobson when they are upholding state and local pandemic-related restrictions, but discounting or ignoring Jacobson altogether when they are striking them down. So at this point in my presentation, I've remained preoccupied, you might even say mired, in the 18th, 19th, and early 20th century constitutions. But I want to turn the gaze in the remaining time of my lecture to the present day. The problem with the fidelity to the rule of law, memorably recounted by Dicey, Hayek, and others, never went away in the context of the police power and other powers of government as well. Nor did the tension between the notion of the police power as a last resort mechanism for protecting individuals against discrete harms, what I've called the sic utere view, going back as far as Lord Coke, and advocated in modern times by Richard Epstein and other deep state worrywarts, versus the more social welfarist progressive model sketched by Chief Justice Shaw and Alger and forged in many important state cases of the 19th and the 20th centuries. We've seen a set of perspectives on the police power that I've described from 19th century commentaries and state courts. One that has been persistent, even though quite misguided from the beginning, is the idea that the police power is truly a suspension power, Carl Schmitt, of course, wrote famously about the notion of the emergency constitution. This conception has been carried along through an extraordinarily thoughtful and capacious body of constitutional thought, both in the United States and abroad. Just as we reject this perspective on the police power, we should be assuaged in our concern that such a power is not and cannot be subject to rule of law constraints, because it can, and it is. The other conception captured by the sic utere principle is that the police power is concerned principally with private harm and externalities, a view articulated in Jacobson by Justice Harlan, but also in particular by earlier state police power cases going back to the beginning of the Republic. But it is not the only conception. And again, the author of a leading treatise on the police power, many leading treatises on the police power, but I'm talking here in particular about the great Ernst Freund, argued that, and I quote, "The care of the public welfare or internal public policy has for its subject the improvement of social and economic conditions affecting the community at large and collectively, with a view to bringing about the greatest good for the greatest number." It was this idea of salus populi, I would argue, that ultimately won the day over a more narrow private law conception of the police power. This move from a conception of the police power as more than an emergent public authority to regulate private property and individual behavior in order to redress injuries is more than rhetorical. It undergirded efforts to create new strategies for improving the common welfare. Indeed, it saw the protection of public health and safety as subserving these more general aims. As to Jacobson and public health crises in particular, it saw the connection between these urgent public health problems and a commitment to the common good. Indeed, the larger context in which these health crises would be confronted, as they are now, would be through public health regulation and carefully constructed mechanisms that would ideally create measured solutions to complex epidemiological and, yes, social and economic problems. Of course, controlling the impact of infectious diseases is only one such wicked problem. The police power, best understood as a regulatory power, is the fulcrum of power to address other key problems faced acutely at the state and local level. And let me, in the last few minutes remaining, touch on a couple of those problems and then conclude. Think, for example, of the power and indeed the obligation of state and local governments to address matters of housing and access to shelter. Early police power cases supported public efforts to deal with urban blight, zoning's purposes, including preventing health and safety harms, while also enhancing the welfare of the community through attention to housing predicaments. Here's how a New Jersey Supreme Court put it in a 1938 case involving the local housing ordinance. The standard for defendants' exercise of the police power was not the advantage or detriment to particular neighboring landowners, but rather the effect upon the entire community as social, economic, and political unit. As a social, economic, and political unit. The court went on to write, "Planning is a term of broader significance. It connotes a systematic development contrived to promote the common interest in matters that have from the earliest times been considered as embraced within the police power. The state possesses the inherent authority to resort in the building and expansion of its community life to such measures as may be necessary to secure the essential common material and moral needs." Housing and shelter present an especially interesting puzzle for the police power and for the competing conceptions of its purposes. After all, in the absence of a constitutional right to housing, the absence of adequate shelter and affordable housing is conventionally viewed as not a form of suffering that results from harm caused by other individuals or even the community writ large, but rather of the absence of opportunity. In our constitutional vocabulary, housing can be seen as a right only under the rubric of a positive rights conception. And so it is here that state constitutionalism is especially apt and even prescient. For we might aspire to a meaningful positive right to housing in state constitutions, although we could really never have an aspiration under the United States Constitution. Indeed, something as recently as May of last year, California lawmakers introduced what would be, if passed, the first in the nation constitutional amendment guaranteeing the right to housing. Or more modestly, we can at least deploy the existing police power under a general welfare model to implement progressive public policy to address urgent matters of housing and homelessness. A second, and perhaps even more controversial use of the police power is in the addressing of economic inequality. To be sure, the enormity of the problem of income inequality defies solutions that are principally state or local. Where constructive redress requires economic steps, the revenue base of all but the wealthiest of American states makes such headway unlikely. And local wealth redistribution efforts face ubiquitous legal, political, and economic impediments. None of this suggests that within limits, we shouldn't try to make progress, but we should be cognizant of the gap between vision and real improvement. The principal goals in the area of inequality, wealth inequality, that can be attained through scrupulous governmental efforts are principally ameliorative solutions to wealth inequality. Talking here about matters such as education, housing, transportation, among other policy areas. These are issues which are elements of our inequality tax, as it were, and can be tackled and should be tackled at both the state and the local level. But as to general strategies to confront directly wealth inequality through steps as bold as, for example, income or asset redistribution, is this a matter of general welfare and therefore a legitimate use of the state police power? The answer I suggest is yes, although I readily acknowledge that the devil lies in the details. Confronting economic inequality is a public necessity, and we can look to governmental authorities at the state and local levels to address this. This is true under even a textualist account of the police power, given the interactive effects of wealth inequality and its impact on health and safety. But under a more expansive general welfare view that I've advocated here, governmental mechanisms to address these impacts are part of the official responsibility to improve general well-being through regulatory steps. The line traditionally drawn between regulation and subsidies is a familiar one, but it's also an unstable one, since we're after all talking not only about regulatory power, but also fiscal power. We can, though, address, as many have written, social and economic ills through a combination of devices, and this will entail a mix of prohibitions, incentives, and subsidies. And the police power, is my suggestion, is a central part of this. I'm going to talk about the taxing power that I'll again skip over in the interest of time. And let me conclude thus. I want to conclude with a cautionary comment. I focused in this talk mainly on the notions of power, governmental power, constitutional power, and have gone so far, at least I hope you'll see this as fairly far, to suggest that the idea of the police power is really embedded in a welfare-enhancing conception of the government's regulatory power. In other words, it is not limited simply to the prevention of social harm, and it is certainly not best understood as a suspension power. However, the first term is relevant as well. And the idea of the police power is connected to, let me be clear when I say first term, since that comes out of nowhere. By the first term, I mean the police in the phrase, the police power. The first term is relevant as well. And the idea of the police power is indeed connected to an ideal of police and policing that is worth interrogating in this era in which policing has become associated with discrimination and destruction, with structural racism and the carceral state. If we are thinking seriously, whether or not metaphorically, of defunding the police, does this mean that we ought to be thinking of defunding the police power? In the main, we can think of policing as not really what the police power is about, or so I would argue. It is about instead regulation, more generally, and enhancing social welfare and the common good. Moreover, this regulation does not always, and maybe not even mostly, need to be about command and control, about law and order. But still in all, we can think about the predicate to the police power as being about police and policing, not about control, but about the social mission of community and of protection. These are certainly harder questions than this lecture can answer or even thoroughly illuminate. But I would just say in closing this, a clearer general theory of the police power should look beyond a conception of this power as just about law and order. It should be about regulatory initiative in the service of social welfare and justice, and in this sense become transformed from a police power to a regulatory power. But even in its remit as a power tied to the police, it should invite us to think more imaginatively about policing and the role of policing authority. So let me stop there. Thank you. I really welcome your questions, and thank you for indulging me for going on so long about the police power.
That was terrific. Thank you so much. Folks, I think you can use the raise your hand function for folks who would like to ask a question. You could also direct message me, and seeing no hands, I will ask a question of my own. So I'm interested in the point you made about a positive right to housing and the police power. And I want to ask the question this way, not knowing these cases, you're talking about the police power to address housing and shelter.
Mhm.
My first question is, so doctrinally, what limitation is the police power overcoming? Like, what is the work the police power is doing? Is it an individual liberty claim? Why wouldn't the government have the power to do something about housing and shelter? Is it a claim that the state lacks this power because the federal government should have it? Is it a claim that individual liberties are being infringed upon? I'm just curious what work actually the police power is doing there. And then is the claim really, do we really have cases where the courts are entertaining the claim that the police power imposes an affirmative obligation on state or local governments to provide housing? Because I'm super excited about that. If the police power has started to mean that, but I'm interested in the doctrinal or the sort of mechanics of how that's actually working. So those are kind of
yeah.
questions, but.
So thanks for your great questions. Let me start in reverse order. Let me dampen your enthusiasm immediately. There aren't, to the best of my knowledge, an enormous number of state cases that have articulated anything by way of an affirmative duty that is sourced in the state constitution that would call upon and mandate efforts on the part of state and local governments to do the kinds of things with respect to wealth income inequality, and even the broad kinds of things with respect to housing. Now, of course, many of you, I was going to say many of you old timers, but maybe even you new timers, are familiar with the Mount Laurel litigation in the context of housing in New Jersey and in other contexts. And so we can maybe hope against hope, although that's a complex story about whether or not that provides at least a distant basis for the imposition of affirmative duties in that context. In some ways, that parallels litigation over education, but leave that to one side. But there's a reason why. When the California legislators introduced some of them last May, it was celebrated as the first in the nation effort to reform and amend the state constitution to actually provide a right to housing. Is doctrinally there hadn't been much of scaffolding for the enforcement and the imposition of a right to housing generally. So I think it's the absence of doctrine and the absence of constitutional warrant that's really the story. I'll say very briefly, in direct answer to your first question, what is it overcoming? Most often it's overcoming the right to private property. So usually where the rubber hits the road in these police power cases is the conflict is a classic and longstanding conflict between government's regulatory authority on the one hand, individuals' right to private property, and that issue will continue to persist. One of the reasons why I bring in the issue of wealth inequality and also housing steps that go beyond adequate housing and look at access to housing and sheltering requirements is they involve money, and they involve the imposition of affirmative mandates on the government, which have to overcome our classic reluctance, if they're going to go anywhere, to have courts enforce requirements on legislative and administrative agencies to actually spend the revenue of the state. And that's an impossibly larger topic that goes beyond just the imposition of the police power. But that is where I think it's happening. It's not just overcoming private property side constraints. It's actually imposing more affirmative mandates and duties. I could say more about that, but
yeah, no, and thank you. We now have a large queue, so
I'll keep it short. Yeah.
Yeah. No. I'm just letting everyone know. I think Jim Blumstein, did you have your hand up? You're muted.
Thank you. I didn't know whether I'd be seen or not. It was not mechanical.
Thanks to Kevin Stack, you were.
The question, thank you, Dan. I think that in kind of building on Ingrid's question, that the question always for me is whether the police power is a source of authority for state and local governments or a limit on that authority. And it has often been seen as limiting the scope of authority. One of the most far-reaching parts of Lochner was the illegitimacy of redressing power imbalances between workers and employers. I think most recently in a case like Lawrence against Texas, that morals are no longer a legitimate part of the public health, safety, welfare in morals. At least a strong reading of Lawrence would suggest that morals legislation is really beyond the scope of the police power. So I'm wondering if that's your reading too, that the police power basically has been used to justify public policy goals that expand the scope of the government. And only recently has that limitation been resurrected in a case like Lawrence.
So I don't, yeah, no, please.
No, that's fine.
So I don't read Lawrence in that way, and more broadly, I don't read the restrictions on the government's authority to regulate morals in the same way. Although I think we come to the same conclusion. What I sort of dismissed in passing in my remarks is, I could talk about the rise of constitutional rights, but I'm not going to talk about it. Your question gives me an opportunity to say a couple sentences about it, which of course the rise of constitutional rights, protections, and civil liberties, from privacy to equal protection, whatever, will and long has been a constraint in the exercise of the police power, period, end of sentence, although those limitations and civil liberties will evolve. So nothing in what I've said suggests that the police power, even a more muscular police power, is a mechanism or means of overcoming our tradition of civil liberties and protections that exist as a bulwark against efforts of the state to regulate public morals, where such regulation is effectively subordination, is discrimination, what have you. It's rather more at the beginning, is there a warrant in state and local regulatory power to undertake the important work of common welfare lawmaking, something that has been denied to the federal government, which is why we mostly wipe away the notion that the federal government has general omnibus general welfare power. I know that point is controversial, but I think it's mostly associated with a limitation on federalism. And we should not find the state and local regulatory authority nearly so cabined, is basically the argument. But certainly you bring in individual rights into that, constitutional rights into that. Those are very important limits that have little to do with Lochner.
I had Mike Vandenberg on the queue. Oh, there you are. You're back.
I popped back. Thank you so much. Dan, I thought that was terrific. I think many of us, certainly in the environmental area, tend to just blithely talk about state power, and we don't really give it a little more thought over time. So I thought it was very useful for you to walk through all that for us. At the very core, I guess my sense of how expansive I'm comfortable with state power being depends in large part if it's grounded in the legislature of a state, in the extent to which a state reflects the preferences of the population on some level. And I'm curious about whether you've looked into or how deep the literature is on what the original conceptions were of the extent to which there might be gerrymandering and things like that at the state legislature level, right from the founding. Is that something you've dived into in the past, and what could you say about that?
No is the short answer. I'm aware of literature. Let's put it this way. I'm more aware of the literature that undergirds state constitutional reforms a century later, when there was everything from Tammany Hall to the state legislators picking their cherry picking legislation and all of that gave rise to this large menu of progressive era reforms to legislatures and legislation, including the rise of initiative lawmaking. But of course, I'm not naive to suppose that all of a sudden we were shocked to find gambling in the legislature, but rather, some of those issues predate and go all the way back to the founding. But whether there is the kind of literature that would, and attention that would draw focus and scrutiny to the kinds of really interesting issues that you raise, I'm not nearly as confident, but it's definitely a place to look. And I think
well, I have to run to do an interview, but I'm going to drop off. But it's not because I'm running for cover after your talk. I thought it was terrific. Thank you so much.
I think we've got time for maybe one more question. Susanna Sherry, you had your hand up and now it's down.
I was basically going to ask a version of Jim Blumstein's question, which is how how do we draw the line between welfare and morals? That is, in the old days, regulating the community's morals was part of regulating its welfare and ensuring its welfare. And in your answer to Jim's question, which was similar to that, you said that the constitutional rights would limit that. But at the same time, you said that often the clash would be between legislation for the common welfare and property rights. So how do you reconcile the fact that legislation for the common welfare, the police power in the, and now I don't remember the Latin, but the salus populi sense,
Yeah.
Can overcome property rights, but it can't overcome rights of privacy, equal protection, and so on. That is, so I see a tension there.
Sure. Well, you're right to see it. Let me walk back a bit. If I left you and Jim with the impression that a robust police power means that we are totally reconfiguring property to diminish its significance and importance to the point where there should be an omnibus power given to the state and local governments to overcome property rights wherever they're there, let me suggest that that's not my point. Takings can't be the entire answer to that, nor can limitations on the taxing power. Property rights are important. And if we'll bracket the issue of economic liberties and substitute process for a moment, there's going to be this continuing tension. And there ought to be this continuing tension because we're going to have to figure out how to balance, as we have over the last 200 years plus, individual property rights with social needs and the common welfare. The civil liberties point I meant to suggest, and that's why I was responding specifically to Lawrence, is, a lot has changed in the 115 years since Jacobson. And one of the things that's changed is there's a lot more things to throw at the assertion of a police power. And indeed, we can see that in the pandemic cases. Some of the cases come out on the side of civil liberties, and some of the cases, in my view, ought to come out on the side of civil liberties because civil liberties have changed and expanded enormously, even leaving aside a corporation. But I say just very quickly on the point about morals, I think that you have to confront sort of what I said about Jim Crow. You cannot understand the police power without confronting the fact that it was designed to serve some noxious aims, and it has been used in the service of some of those noxious aims, or aims that should be troubling to us. And one of the areas in which it's served aims that should be troubling to us is a general omnibus basis to restrict public morals. But its origins lie in the charge to be able to regulate public morals. So we can't just say, well, I'm going to take the part of the police power that I like, which is regulating public health, because we're all in favor of public health, and leave out the part I don't like, which is telling me, whether I should toss dice in the alley or whatever is. You can't. You have to understand in the context of morals. I know we're out of time, Ingrid, but I had a part in the script that got left on the cutting room floor, and I was talking about regulation and the aspiration for regulation. And the paragraph I just want you to know said, most of what I learned on this subject can be relearned by reading Ed Rubin's book, Beyond Camelot, which is, to the best of my knowledge, available at your local bookstore. And if you cannot access your local bookstore, I'm sure is on Amazon, if on remainder or at a more generous price. So
Thank you so much, and what a wonderful ending, and what a great shout out for Ed Rubin's book. Thank you so much for this wonderful lecture. I'm thrilled to have you, quote unquote, here in Nashville. I don't know what kind of hot chicken you're going to get up there in Chicago.
It's not going to be the same.
But come down here and get the real stuff anytime you want it. So thank you so much.
Thank you. Thanks.